Now, we are recording, so I will be turning that over to our host today, who is Carla Zemnick-Sicer. So go ahead, Carla.
Thank you. Can you hear me?
We can hear you.
Thank you. So good afternoon, everyone. As Dave said, I'm Carla Zebnik-Seifzer. As many of you know, I am both an advisor and the president of ClearStep Financial. I also would like to welcome you to today's estate planning presentation. Our goal at ClearStep Financial is to help educate and guide our clients through our ever-changing financial world. To help us accomplish this goal today, I'm pleased to introduce to you our guest speaker, Nathan Eckley, an attorney and partner with Affeldt Law Offices. And Nathan, you'll let us know if you would like to answer questions during the presentation or after. You can let us know that, but I believe everyone will be full of education, information, and enlightened. And with that, I welcome Nathan. Thank you, Nathan, for being here today.
Thanks, Carla. So if everybody could hold questions till the end, I did reserve time at the end, but I want to get through the educational part of this. And so the first part is, let me educate you a little bit about myself. I am a Missouri farm kid who grew up in the middle of nowhere, sitting on tractors, thinking great thoughts. And one of those thoughts was, I don't want to be a Missouri farm kid for the rest of my life. So I decided to go to school. Did my undergraduate degree at the University of Missouri, Columbia, Mizzou. Any Tigers out there? My background is in agriculture still, agricultural economics, but my ag economics advisor said, maybe you want to do something different. How about looking at the practice of law instead? Fell in love with the practice of law in undergraduate while I was taking some graduate level classes. Went to law school in Chicago. It was John Marshall Law School, which is now called the University of Illinois at Chicago Law School, and ultimately met my lovely wife, who is a Wisconsin native, and she convinced me, or maybe we both decided in the royal we that we were going to move back to Wisconsin. I've been practicing for over 20 years. I still maintain my license in Illinois and Wisconsin. Most of the things I'm going to focus on today are Wisconsin specific. So just keep that in mind as part of the presentation. If you have questions that are state specific, obviously contact your local advisor, talk to a trusted professional in the field. But we're going to talk about some estate planning basics today. And a lot of these things they work no matter where you happen to be at. So let's start with, why do you do an estate plan? Why do you do any of this planning? Why do you come talk to an advisor? Why would you talk to a lawyer? And your hope is you want to avoid mistakes. Mistakes are very costly. And the mistake that happened here is, this is my 4-year-old. He was about 2 at the time, and the mistake was he got caught. He got caught throwing a Hot Wheel at his older brother, and he hit him pretty squarely in the forehead, enough to earn a trip to the emergency room to get some stitches. But we want to avoid those mistakes. As a parent, my job is to continue to parent my 4-year-old so he doesn't throw Hot Wheels to get his point across. But ultimately, as an attorney, my job is to try to counsel clients on how to avoid estate planning issues. And you can't with proper planning. It just takes some extra thought. So let's talk about the types of ways to distribute assets. And some of the basic ones that most people think of is, well, how do we own assets? The most common way, especially for any married couples that are part of the group today, the common asset that you own is something that you own jointly with your spouse. And so that means that there's an automatic right for either one of you to access the asset, use it for your benefit. But some things aren't. Some things you've worked very hard for all by yourself, and therefore you might have assets that are in your individual name, and they might have beneficiary designations. Here at ClearStep Financial, my hope would be if you have the ability to add a beneficiary designation to your account, and that's the appropriate way to transfer that asset, that you would complete that document. And that's an effective distribution document. Typically, those are things like bank accounts, life insurance, and retirement accounts. But it might need to be a more formal distribution document, and that's usually what people think of when they're talking about estate planning, and that's often a will. It's not the only distribution document. We've talked about some other ways to distribute assets and ownership and beneficiary designations. That's a pretty common one. But what I tend to find more common these days is that many clients of mine are coming to talk to me about trust planning. So a trust agreement, a separate asset or a separate agreement that controls certain assets that are meant to be distributed without any court supervision, without any sort of thought process where you have to go fill out additional paperwork, just an agreement where you've named people to be in charge, you've titled certain assets, and the job is to get those assets transferred after you pass away. So let's talk about ownership rights first. So if you jointly own an asset and you want it to pass to someone, well, the way to hold title is a joint tenant with a right of survivorship. And for spouses, at least here in Wisconsin and in Illinois also where I'm licensed, if you own an asset with your spouse, there's an automatic right that your spouse is going to receive the benefit of that asset if you jointly own it, even if you don't add these magic words. If for some reason you want to jointly own things with someone else and you want to create that automatic right of survivorship, you would want to make sure and confirm with either the custodian of the account or the way that the account is held, or the words, sometimes called the magic words of survivorship rights, are added to that account or to that transfer document or to the ownership document. Because if you don't add those things and the person you jointly own something with is not your spouse, well, then you're considered to hold it as a tenant in common. And I use myself as an example throughout my presentation, so I want to make sure I sort of clarify that. A tenant in common might be, for example, when my brother and I inherited some farmland in Missouri, people thought it was jointly owned. Well, sure, we jointly owned it, but we're brothers. We're not spouses. And we both had different ideas about what we wanted to do and who we would give assets to after we died. So we owned it as tenants in common. We didn't have any of those magic words. That might be appropriate. You might need to own something separately with someone who is an individual where there's not an automatic right for it to transfer to someone else. But I just want to make people aware of it. That is another type of ownership right. And if you have a tenant in common interest in an asset, you have the absolute right to distribute your share, whatever that might be, to whomever you want to. Keep in mind, and this is really a focus on Wisconsin's marital property law, certain assets, regardless of how you hold title to those assets, may have spousal rights to them. Keep that in mind as part of your overall plan. If you do have questions about spousal rights in a particular asset, well, that's a conversation with an attorney who's licensed and understands those rights. So there's your sort of ownership rights. One of the most common distribution planning documents is a beneficiary designation, though. Whether it's called a POD, so payable on death, or TOD, transfer on death, that is an asset where you have agreed with the custodian of that particular asset, or you have provided documentation that says, if I still own this document or this asset at the time that I die, the document or the way I hold title or the way that a beneficiary designates it automatically transfers to whomever you've named, whether that's a person or persons, maybe it's an organization, but you've named the specific person, entity who's supposed to receive that asset when you pass away. Beneficiary designations aren't subject to probate. I mean, they're not subject to the probate court jurisdiction. And if you write a bunch of information in your will about an asset that's beneficiary designated, it doesn't matter. Beneficiary designations control first before any of your other distribution documents. So just keep that in mind. And I provide this warning for all types of planning documents. You just want to make sure that if you're using a beneficiary designation to transfer an asset upon your death, that it meets your overall planning to distribute your assets. So certain beneficiaries, it might be appropriate for them to be a direct beneficiary of an asset, and certain people it wouldn't. Again, I pick on myself. My children, I have 6 of them, they're all still minors. So by law, none of them can manage their own assets. And they range from 17 down to almost 3. So there's a long range there of when are they going to be eligible? When are they going to be capable of managing their own assets? Well, I don't know when, probably not for some time. So my beneficiary designation planning currently doesn't include my children directly in any way. My hope is it does eventually, but they all have to mature. They all have to prove to dad that they can manage their finances. And they all have to prove that they deserve to receive 1/6 of every dollar that dad might have left over when he passes away. Beneficiary designations, what types, and these are the most common ones that I see as a practitioner. Oftentimes bank accounts are beneficiary designated. So your bank account at your local bank, and that might include a certificate of deposit. It might include a savings account, a money market account. Oftentimes those are beneficiary designated. Life insurance, that would very typically be beneficiary designated. Again, I'd pick on myself. So life insurance might be appropriate for me to name my spouse as the primary beneficiary of my life insurance policy, but it wouldn't necessarily be my children as the contingent beneficiaries. A more appropriate place, if my wife and I died at the same time, would be to distribute that life insurance to a trust established for the benefit of my kids. You might beneficiary designate retirement accounts, and those are very typically beneficiary designated to individuals, to heirs, to the sort of natural issue that you would think of. But you can also do that for real estate as well, and that's true here in Wisconsin. We use a form called a TOD deed or a designation of TOD beneficiary. It's a recorded document that says that a piece of real estate, once the owner or owners have passed away, it automatically transfers to whomever you've recorded as the beneficiary or beneficiaries. Illinois allows that as well. Many other states do. You just have to decide that a piece of real estate is correct to transfer by beneficiary designation. If it is, use the correct form, get that document recorded. I'm actually going to use that as an example later on, so put a pin in that and keep that in mind. Well, what assets are appropriate for beneficiary designation for real estate? Well, let's talk about that in a little bit later in my presentation. And again, that same warning. If you use beneficiary designations, just make sure it coincides with your overall estate plan and your other distribution documents. It can be a very powerful tool. It can also be a tool that can greatly or disastrously affect improper planning. Here are the most common mistakes when I see beneficiary designation planning. I see all of the cash is beneficiary designated to the people who should receive it, but if there's an estate proceeding or if there's a trust administration, neither of those entities has any cash assets now. And so now we have hard assets, but no way to pay the bills for those hard assets. And that would be very typical in most probate administrations that I see. All the cash is beneficiary designated, but we still got to deal with the house and the car. And the house and the car have expenses. And the house and the car, unless someone's getting it outright, they're unlikely to pull money out of their own pocket just to pay for that expense for the estate in the interim. So you got to keep that in mind. If all the cash is beneficiary designated, if you have another administration to administer as part of that process post-death, you might have some cash flow issues. Incorrect beneficiaries being named. You want to be very precise when you use beneficiary designations. We've kind of gotten away from the multi-generational use of the same name. We don't have many Bill the Firsts, Bill the Seconds, Bill the Thirds, Bill the Fourths, but that still exists. And we do have people who have very similar names who might be in the same family. So you want to make sure you're very precise when it comes to the beneficiary designation. One of the most common ways to denote a specific beneficiary is on the beneficiary designation. It will ask for that beneficiary's social security number. So just keep that in mind. You might need to gather information related to that particular beneficiary so you can be precise. Some beneficiary designated assets have tax liability associated with them. And this would be very typically if you have traditional retirement accounts, IRAs, traditional, not Roth, that there's some income that might transfer that there's no tax that's been paid on that. And so a beneficiary who receives $1 million of an traditional IRA as a direct beneficiary, you want to make sure that that's an appropriate person to understand that there are some income tax issues. And so they don't go spend that entire $1 million and have none left to pay Uncle Sam when Uncle Sam comes knocking at the door. So keep that in mind. Qualified accounts, that's what I was just talking about, assets where there is a delayed tax effect. It might be appropriate to transfer qualified assets to a person. It might be appropriate to name an estate or a trust as a beneficiary of a qualified account. Just understand there are some tax consequences to that. The highest tax rates are often paid by estates and trusts. So if you're concerned about taxes, you want to make sure and have a sit-down conversation about the tax effect of naming a person versus an estate or a trust as the beneficiary of a qualified account. And again, just a reminder here in Wisconsin that marital property creates some spousal rights, regardless of whether or not there might be assets, and also multiple marriage situations can create some of those scenarios where you might intend to benefit a spouse, but that might be their sole asset. And so if you have children from a different relationship, you need to plan accordingly. And again, just the warning, you must coincide with your overall plan to distribute assets. So let's talk about a very typical document that's used to distribute your assets, and that would be wills. What is a will? It's just an instruction manual. A lot of people want to make a very complicated 400-page instruction manual. You don't. One of the best wills I ever saw was one sentence. I give everything to my beloved wife, and if she dies, then to all of my children, and she's in charge. That was it. It was missing some information I would have liked to know, but it was straight to the point. It was a well-drafted document. It was a well-drafted instruction manual for a family that everyone got along. They were very close. There was no question that their mother was in charge if their father passed first, which was true. And the instruction manual is usually effective only when we go through the probate court system. Now, there are some exceptions, but that would take an entire separate luncheon to do that. And I don't think Carla and Kevin are interested in paying for esoteric discussions over lunch. That's a conversation to have, but just understand that instruction manual is normally administered by the court system. It is normally judicially supervised or enforced. And therefore, it's for people who tell me, well, the instruction sheet, I have a will, so we don't go to probate court. No, the answer is you go to probate court to effect that will. And why would you want a will? Distribute your individually owned assets upon your death. So we just talked about beneficiary designations. Well, Nathan, why would we have a will then? Wouldn't everything just pass naturally by beneficiary designations or joint ownership? Not necessarily. What if you're the surviving spouse? What if you're one of those scenarios where there aren't children or we don't have a spouse at all, and maybe we want to pass it to other people or other institutions, or maybe no one needs it and we want to just give it away at that point. And so we might want to process in order to make sure that that's taken care of. Understand that the assets are controlled by a personal representative. That's the term we use here in Wisconsin. In Illinois, the term would be executor or executrix or administrator. It can take different names, but ultimately the person who's in charge is appointed by the court, and they are in a fiduciary responsibility to follow the instructions in the will. And that's why you want to leave them a very complete instruction manual. A will is subject to probate court jurisdiction. It is subject to court supervision and oversight. And the goal here is to avoid what are called intestate laws, which is the default rules. And I'll give you the most striking example I see more often these days, which is for people who don't plan and they don't have a natural heir at law. They are not married, or at least not married at the time they pass away. No children. They don't have any siblings, so they don't have any nieces or nephews as well. They're an only child, but they've essentially become the bucket of inheritance over the years from their own parents or maybe some other distant relatives. And now they're the last person in their line, and there is no natural person to give it to. Well, if you don't write a will or you don't have a comprehensive estate plan for what to do with those assets, the default rules there tell me give it to your next closest relatives. And if you're not married, no kids, no siblings, no nieces, nephews, no surviving parents, your next closest relatives are your cousins. And I don't know that you intend to benefit your first cousins who might be many times removed that you haven't seen since, Aunt Betty's wedding 48 years ago. So you want to keep in mind that the goal here is to avoid default rules that most people don't want, but that we have put into place as part of the legislature. Well, we don't know, so this is our best guess. So please don't leave it to best guesses of lawyers and legislators to figure out what to do with your stuff. Come up with a plan, and that might include a will. So some things to consider when you're drafting a will. What assets are subject to the will's distribution plan? We just talked about certain beneficiary designations or joint ownership. Oftentimes people confuse that. One of the most complicated wills I've seen recently was one my partner is involved in. And it was someone who went and prepared their own will. It was very clear they didn't have any professional help, but they listed all of their assets in the will, even though the vast majority of those assets had direct beneficiaries listed. So writing that down in your will didn't change who the distributions are. And ultimately, that meant that there were no assets to distribute under the will other than a couple of specific distributions to some friends, some items, some tangible personal property. And so do I think that that was the intended benefit? I don't know, but we can only say that in that will planning, it was poorly planned because that person didn't understand that beneficiary designations control before the will does. Another thing to consider is, who do you trust to be a personal representative? That's someone who serves in a fiduciary capacity, and that's not everyone. I'll pick on my kids because none of them are old enough yet to do this. My 17-year-old is great. He's a smart kid. He's an engineer. But being an engineer tends to give him a low emotional quotient, low EQ when it comes to people. My 14-year-old daughter, though, has a very high EQ. And she's also, her nickname's Little Mama, and Little Mama keeps everybody alive who's below her. So, and deals with a very overbearing brother and two legally trained parents at the same time. So I know that my daughter, when she turns 18, has the capability to take on that yoke of responsibility. And I hope all of my children are, but I'm unlikely to go 6 for 6 when it comes to productive citizens of the world. If I go 3 for 6, I've already made the Hall of Fame statistically as a parent. The goal is still 6, but I need to be realistic as to who do I trust to do this. Someday I hope it's all of my children, but I need to look at the people that are likely to be there and their role and how well they handle responsibility already. And so you need to consider that. You also need to consider the 2 types of distributions. Personal property, something that normally has very little real world value, often has very high emotional connection to the beneficiaries. I've never seen people get more animated, angry, excited than when it comes down to distributing things that have no real world value, but that they love dearly. Mom's wedding ring, grandma's family Bible, mom's lawnmower, which was a very unusual dispute because every phone call involving mom's lawnmower, this is a real world example, every phone call to her office involved the cost of at least one more lawnmower every time. And yet that didn't stop 2 people from arguing about it. And then the residue. This is where the real value is. This is the everything else, because tangible personal property usually amounts to a whole lot of tchotchkes, but not a whole lot of dollars. The residue in your will provision includes the real world value. And this is where you would typically benefit specific people or organizations in sort of a group or a class way. That's where the real value is. And then sometimes there are special provisions that apply in a will. For example, maybe you know who shouldn't receive something ever under your planning, and so they get specifically disinherited as part of your planning. Maybe you understand that if there are contests, if people decide to be litigious because they've got a lot of money and they like to pay lawyers to go argue about stuff, that might change the distribution plan, called interim provisions. If you argue, you get nothing, or you get the proverbial dollar. And so there are some of those conversations you need to have with a trusted and experienced estate planning attorney. Do they need to be provided in my document? Thankfully, most of my clients don't have that, but that is a testament to them making sure that any beneficiaries have realistic expectations of what they're supposed to receive and not unrealistic expectations that they get everything. Just one quick note, if you're a married couple, I mean, often we talk about, having will planning as part of the overall plan. But when you're a married person, you often already have joint assets with a right of survivorship with your spouse. You often have them listed as the primary and sole beneficiary of many of your other individual assets, like retirement accounts. And so it's very unlikely that we have this surprise scenario when the first spouse passes that we're going to go to probate court. It happens, but in very unusual circumstances. Unfortunately, if you're a married couple and you come to my office, I don't know who's going to die first. So each of you will need a will for whichever happens first. If I did know that, which I don't want to know that, I would do a couple of plans. People would pay me a lot of money, and then I would retire from the practice of law and go into the practice of prognostication instead. Let's couple what a will does with the process that it's involved in. And probate is a process. Probate court is very much a process. I had a very unfortunate conversation today with people who live out of country. They are not citizens of the United States. Their only child, not married, no children, passed away suddenly, and no will. So we have a probate process for the assets that are subject here in Wisconsin to Wisconsin law, even though the beneficiaries are his parents who live overseas. Ultimately, first I need to determine, do we have a probate? So probate court isn't designed to handle every single little thing. There's a gatekeeper, and the gatekeeper that we've decided to use is if we have $50,000 or more of assets that the probate court needs to be involved in, then we're going to petition the court and use the probate court process. If it's less than that, there might not be a reason to go to probate court. Now, I have been to probate court when there's been less than $50,000 of assets, but it's because there were other contested issues often. We have to determine who the interested parties are. And I know I use that example for the sort of not married, no children, no siblings, no nieces, nephews, no surviving parents, first cousins as beneficiaries. But we have to determine who those people are because they may receive notice even if they're not a direct beneficiary under a will, or they're not going to receive a distribution under some other type of distribution document. But they're entitled to notice. And that can create sort of this open process of, well, a lot of people got a notice, and if any one of them is a problem, well, that's going to make the probate process longer and more costly. If there is a will, we do need to validate the will. Thankfully, I've rarely been involved in situations where I thought that there were fraudulent wills, but I've seen it. I very rarely have been involved in situations where we didn't find the original will, but a copy was sufficient. And every once in a while, I come across well, we found a will and somebody scribbled all over it. What does that mean? Well, we do need to talk to a judge about that for sure. So, and then the process, the goal is we need to gather this decedent's assets, and then we need to administer them. We need to make sure and marshal them. We need to determine their values. We need to pay their outstanding debts, their taxes that might be owed. We may need to resolve disputes. If anybody has ever heard the horror stories about probate court, well, just multiply that by 10 because that's every day in my office. Yep, we're going to resolve disputes. And then ultimately, we need to distribute whatever the remaining assets are after this process to the rightful parties, whoever that might be. And again, we might need judicial supervision during this process. There might be things where a judge needs to make a determination and bang a gavel so that we can get through this process and ultimately be done with the process. Common issues in probate. It's very technical. If anybody has ever served as a personal representative or an executor or administrator of an estate, you can probably sort of attest to there are real technical rules that apply. And if you don't know them, it's a good way to get tripped up. Good record keeping is essential. If you don't have good record keeping, and sometimes you're thrust into that position, the deceased person didn't keep good records. They were a collector, not a hoarder, just a collector of all things ever that they've kept in their house. And it can be hard to find the good records. You can find lots of records, but they might not be useful to you. It might be from accounts that were long closed. Might be from accounts that they've already gotten the toaster, and the toaster is sitting on another pile of 17 toasters because that's what that person liked to do, open accounts and get toasters, but not keep good records. Tangible personal property and the emotions that come with them. And then everything else and the emotions that come with them. And the focus there is when people pass away, grief and greed make people do weird things. And I can't tell you how anybody's going to act when their loved one passes away, but I'm not surprised anymore when people don't act the way we would expect them to. We always get into valuation disputes. Right now, I am the court-appointed trustee of a trust in another county because they had to go out of county to find someone foolish enough to get involved in this matter. And I've got a classic car. And it's an argument about what that classic car is worth. Well, when it wasn't running, I got nothing but kick the tire offers. Now that it is running, I continue to get just kick the tire offers, even though I know it's worth more than that. So I've got to figure out how to get real world value. And if I asked the children of the deceased, I got values all over the place. So from it's not worth anything, it's been sitting in the barn for all these years, to it's the most valuable thing in the world. It's going to get sold on one of those online auctions for hundreds of thousands of dollars. I doubt either one of those were true. And understand that there's always delay. Probate is not a quick process. One of the best answers I ever got was from a judge who's a little bit of a character. And I said, well, why can't we make this go any faster? Well, in every counselor, in every matter, every probate matter I've ever been involved in, at least one of the people was dead. So we're not in a big hurry. I thought it was funny later. I didn't think it was funny in the moment. But then we need to come up with contingency plans if there are delay, and that can be part of your overall planning process as well. Okay, so just keep that in mind. Common myths about wills in the probate. My will distributes all of my assets. We talked about beneficiary designations. My specific example, a will that lists things that were already, beneficiary designated to other people. Doesn't mean the will controls them. Ultimately, things walk away before we get into the court process. And sometimes it's very hard to draw those assets back if they're gone and no one can prove where they went to. This is my favorite. My personal representative is in charge immediately after I die. No, they're not. No one is in charge until a court appoints somebody to be in charge. And so the number of people, well, I'm mom's personal representative in her will, so I've been collecting rent for the last 6 months after she passed away. And I guess we're ready to start the probate. Well, you didn't have authority to do any of those things. Now, where'd you put the money? Well, I put it in a segregated bank account and I'm keeping good records. Excellent. Where'd you put the money? I had to spend it a little bit on some expenses. Okay. That's going to be a very difficult conversation to have later with the beneficiaries who are going to need an accounting as to where you put that money. Another myth, it resolves conflicts between beneficiaries. It does not. If you got people who are beneficiaries and they don't get what they think they're supposed to, it's never going to resolve the axes that they have to grind with each other. And it resolves the conflicts between non-beneficiaries. People who don't receive anything still talk to their spouse, friend, grandchild who is the beneficiary and tell them what they should get. And you can never stop people from whispering in the ears. Those non-beneficiaries tend to drive conflict. I use myself as an example when my grandma Eckley, so my dad's mom, when she passed away, it was a trust, and we were trying to avoid the court process. I learned more things about my aunts and uncles, stories that I wasn't told because they were inappropriate to tell young people. And I didn't really want to know those things. And ultimately, it led to a lot of hard feelings. But the worst was when people couldn't agree on the distribution of the tangible personal property out of my grandmother's house. There was an estate sale. And 2 of my cousins' wives, so in-laws, what we commonly call outlaws, got into a fist fight because they weren't getting the thing they wanted to in the front yard. Cops called, punches thrown. And these are people who don't get anything. Plus, they were there to bid on assets, not to just get it. It was a very complicated process for me to understand as a rational thinking person. You pay the money and one of you will outbid the other one. And if you really want it, you'll pay an extra $1, right? Nope. That was something they could not get in through their heads. So that's why we tend to think about, well, what are some other ways we can avoid all of that process? And that would be very typically trust agreements. I could get into a very complex discussion. I could spend an hour talking about trust agreements and their perfect use and what to draft and some considerations. Ultimately, it's just too much to go through. I'm going to give you the core concepts. So a trust agreement controls the assets that are titled to the trust or ultimately pay to the trust, but none of the other things. So for example, during your lifetime, if I set up a revocable trust with my wife and said, hey, we're going to retitle the house to the trust. Well, sure, the house is part of the trust, but we already owned it anyway. And it's not like if I put it into the trust, I don't have to mow the grass, or I don't have to pick up after the kids, or I don't have to play dodgeball, or she doesn't have to yell at me to go do all of those things that I just said. We just own the house as trustees of our trust, but we don't notice the difference. Do we still have individual accounts? Sure. I have a retirement account, 401k, an IRA, traditional IRA, or Roth IRA. Those are things that are in my individual name. It's not part of my trust, and it's never going to be part of my trust, my hope, because those things can be distributed. I hope to use it all. I tell my kids all the time, your mother and I are going to spend it all, so go good jobs. Thankfully, they're on their way to doing that. But you got to remember which things are controlled by the trust and when. During your lifetime, the assets you fund to your trust are controlled by the trust in its terms, or after you pass away, assets that are beneficiary designated to the trust, they are then controlled by the trust in its terms. But some things may be outside of your trust. Those assets are controlled by a trustee. That should be you during your lifetime. And then a very trusted 14-year-old daughter, another trusted individual that you know can handle those if you're ever incapacitated or after you pass away. Remember, creating the trust agreement is to avoid the probate process. So it's not subject to probate. I should put normally, because when everything goes well, we don't need the court involved. But when it doesn't go well, when you put trustees who can't do their job in the trust agreement, or you incorrectly title assets, we may need to go through the probate court process to deal with those issues. And a trust is used both before you pass away and after you pass away, and everything that happens in between. Whether you're incapacitated, whether you just resign because you don't want to deal with it any longer, understand that this is a unique estate planning tool that spans a longer period of time. And it is not just for the top 1% of all asset holders. It can be very useful for different people for very specific reasons, because they believe that they don't need judicial supervision, but that direct beneficiary designations are inappropriate for some reason. So I'm going to use the very typical, well, we own the house and we want to make sure that the kids get it. It would be very unusual, but every once in a while I see an owner of a house who adds their child or children as the joint owner with a right of survivorship, magic words, for the primary residence. That's possible. The downside is if I were to make all of my kids joint owners of my house with my wife right now, they're all minors. If anything were to happen, well, then minors can't be in control of assets anyway. So that's sort of useless if the disaster happens. They can't run the house. My 14-year-old could, she just couldn't legally do that. But ultimately, joint ownership is one way to pass it, but it's only for a very discrete type of situation. And this would be very typical. I'll give you the one that I saw that I thought was perfect. A client of mine, she had the three children. The good daughter who's been divorced 4 times, and the bad son. And the good daughter, oldest, she sold her own house because her husband had passed away, the kids had moved out, and she agreed that she and mom both sold their own houses, and they bought a house together so that the daughter could take care of the mother together. But they equally contributed, and the daughter had agreed, well, as long as mom can be independent, this way I can watch her and we won't burn through her assets that she'll have to go to a nursing home or she'll have to go to a skilled care facility. So it was a great way, but both of them contributed. So it was very much a partnership between 2 owners. And that made sense that the survivor of the 2 of them would receive the asset. I did warn, my client was mom, but I did warn the daughter, like, hey, you own this together. What happens if you die first? Well, technically mom owns it. Thankfully, mom's planning always involved that daughter's children, grandkids, just to make sure that, hey, if this accidentally goes to grandma, it's going to come back your direction. That's part of the planning. So, but that made sense to me. But that's a very rare scenario where I want the next generation or beneficiaries to own it. If your beneficiary is a charitable organization, well, I definitely don't want to co-own my house with my church. It's a wonderful, organization, but we don't want to do things together. That's not a right way to do that. You might add a beneficiary, and that's great unless you have 6 kids, because one house doesn't divide 6 ways very easily. And if my wife and I both died and all 6 of our kids had to own it together, there's no way that they're going to agree. I'm not foolish enough to believe that. I mean, my brother and I couldn't agree on how to own something together. I can't imagine 6 people trying to own something together. So it's a very discrete scenario. And typically the beneficiary designation I see very often in the up north getaway property, the hunting land, the cabin, the cottage, the thing you want to stay in the family. Great, that might be a way to beneficiary designate. Just understand that, again, the more Indians you have, the less chiefs you have in that scenario. So it's got to be the right dynamic for those beneficiaries. You could transfer the house by will. We can go through the court system. But ultimately, what's the likelihood that the will process and the will and probate process are necessary? It seems pretty low. Most beneficiaries of wills, well, they just want everything sold. They just want the cash. They don't usually want the house. Hey, we grew up in there, and all I can remember is dad, making me walk out to cut my own switch kind of scenario. That's very much my boyhood. In my scenario, my brother lives in farms with my parents back home, so he should have it. I can't bring a tractor all the way up to Brookfield, Wisconsin, or bring cattle or chicken or goats or sheep or whatever. That's not going to make any sense. I don't need any of those things. So all those should stay there. My brother should absolutely own it. I don't know what my parents' planning is, but that might be a scenario of, hey, maybe we go through the court system. He should get certain things, and if they want to give us anything else, I'd rather have the money, not the things. I don't need them. But most people use a trust to transfer the house now. Why? Even if it's sold, it provides a non-probate, non-court system in order to distribute the asset. And if for some reason that one of the children really wants the house, well, they can work it out with the trustee as part of that distribution, and they don't need a judge to supervise that process. And last concept I want to cover is, well, why do we do any of these things? Boy, this is a lot of time and effort, Nathan, and it costs a lot of money to hire a lawyer, and it does, and I agree with all those things. But you plan because you never know what's going to happen in the future. And you want to write it down so that you don't end up in the worst case scenarios. And my worst case scenario was the picture on the left there. When my now 7-year-old was 5 weeks old, we discovered, because we went to the emergency room, that he had a rare heart condition. And so that's him on all the bypass machines when there was a legitimate question of whether or not he would make it, whether or not I would have a second son at that point. And so we put planning into place because we want to avoid those situations. Tomorrow is not promised to anyone, and not writing it down, not creating a plan is probably the worst mistake I ever see for clients. It's the most costly. It's almost always the one that ends with the most hard feelings, because when you don't have instructions, when you don't properly temper people's expectations by creating a comprehensive plan, they're going to think the worst. That's human nature. And so you want to make sure to plan. For me, it's the disaster. Thankfully, it didn't turn into the disaster. Last November, after multiple procedures and many, many trips to children's hospitals with an electrophysiological pediatrician, they fixed my son's heart condition. And I couldn't have been happier as a parent. But that's just one potential disaster that we were able to avoid. I still have all of the other things I need to deal with. I still got a very overbearing 17-year-old. I still have a very responsible but short-tempered 14-year-old daughter. I still have a 12-year-old who dances around the house and, bebops all the time, and she buys things for love. So we have a lot to work on there. I have a 7-year-old who's probably never going to be eligible for typical health insurance because of a pre-existing condition. I have a 4-year-old who likes to set fire to everything other than just throw Hot Wheels. He's wonderful on camping trips as long as you keep him near the fireplace. That's it. And then I have a soon-to-be 3-year-old who's learned all of the worst things from all of the children in front of him. So I have to come up with a plan. And that plan is very specific to me, but it's to avoid the worst case scenario. And the worst case scenario would be that mom and dad don't tell people what to expect, and therefore they come up with their own version, and then that would drive my kids apart. I don't want them to ever fight with each other. I watched my dad's family do that. They blew themselves up after my grandmother passed away, to the point people didn't talk to each other. They went to the grave, not speaking to their own relatives, that's a hard thing. And that's what I want to relay to people. This is why you do the planning. This is why you sit back and you look at every asset and you talk to your advisors and you talk to professionals, you talk to a lawyer, come up with a plan, because in the end, when you come up with the comprehensive plan, it is all worth it. Questions? I'm going to look online. Yes, ma'am. And I will repeat the questions for anybody who's online. So the question is, what is an irrevocable trust? And I'm going to contrast it with a revocable trust. So very much so. So the question is what is an irrevocable trust, and is it binding, and can no one change it? All of those are true. A revocable trust, which would be a more typical planning tool for most of my client, means, well, it's revocable. It also means it's amendable, it's changeable. You can do whatever you want to. It's your thing, and the assets that you put in there are still for your benefit. An irrevocable trust is pretty much the opposite side of that coin. The irrevocable trust is meant to be a static, lock everything up, we're not making any changes. An irrevocable trust planning is appropriate, again, in certain scenarios, but it's very typical for irrevocable trust planning to be used for asset protection and for Medicaid Title 19 planning, meaning we believe we need to protect an asset, and we might need to be a client that might need to be eligible for public assistance in the future, and we want to protect the asset that's funded to the irrevocable trust. I can only tell you that you think it's two sides of a coin, but it's really like a 20-sided dice when you actually start to get into these issues. I often see irrevocable trust planning not well thought out. The only asset that's transferred to the irrevocable trust is mom and dad's primary residence, that ultimately turn around later and need the sale of the primary residence to fund their transition to a downsized facility, but it's appropriate for them. Well, then they have to go ask the trustee, which might be one of their kids, but almost always when people transfer assets to an irrevocable trust, they think they're still in charge of them, and they are not. They have given it away, and they've given it away potentially to a family member who's going to monitor it, but that family member now has an obligation to keep it and not give it back. I spend more time undoing irrevocable trust planning than I actually do putting in place irrevocable trust planning. And I would just tell you, it's a good tool. It's not, irrevocable trust planning is a tool that needs to be, it's not like, it needs to be for a particular scenario. And when I hear people who come to me, well, I'm afraid that the nursing home or the government's going to get all of my assets. My typical answer now is, and it didn't used to be this, well, I'm afraid you're going to need those assets to get into the nursing home. And if you don't, you're going to wind up in the worst place possible. You're going to wind up in the care facility that doesn't pass the literal smell test. Just doesn't. If you've ever had a loved one who's in a facility that is, it's a warehouse for aging people, and there's 4 people who are on call down an entire wing filled with high needs individuals, I don't want them to not have access to their assets. That's a philosophy thing. If you're using irrevocable trust planning, you're giving away the asset, you're transferring it to the irrevocable trust. My understanding would be, well, then we've decided we never need that asset back at that point. And predominantly, most of my clients can't 100% guarantee, no, I don't need that ever again. Okay. Okay. Yes, sir.
Okay, so you've got a revocable trust, and you've got the successor trust all in place.
Mhm.
The author or the current trustee passes away. We've been told and then the revocable trust becomes irrevocable.
So the question is about when a revocable trust, maybe I'll summarize. When does a revocable trust become irrevocable? I would want to know who funded the trust. So in that scenario, the successor trustee, I hope, is also the grantor, the settlor of the trust. And yes, if the grantor, so I'll use, again, myself as an example. If I'm not married and I don't have children, I don't have any responsibilities, I know my wife's ears are tingling right now. You can't get out of this. We're in it till the end. But if I'm out in charge of myself and I have no other responsibilities, sure, everything that I transfer into that trust, I should be in charge of. I should be the trustee. But if I die and I'm the current serving trustee, well, it does say in our trust documents, well, it's irrevocable when the creator of the trust dies. But I could still be alive and I just become incapacitated. And maybe I've named my loving brother to be the successor trustee. And he says, I'm busy farming. I ain't got time for this. And he just up and quits, or I don't know, he falls off a tractor and gets mowed up and he's gone. And then my sister is next. Just if I'm still alive and I created it, I'm the grantor settler. It's not irrevocable until I die. And so it's always, which way are we looking at it? Just because I can come up with a scenario where a successor trustee dies or is unable to serve, that doesn't necessarily mean that particular trust is irrevocable. But yes, when I die, not if, when I die, if I have a revocable trust, at that moment, it should switch over to an irrevocable trust, meaning nothing can change. Nothing changes. Why? Because then it tells, well, who to distribute the assets to. That's all they have to do at that point. And it should be a very straightforward process. And that's very typical for most people. Sometimes I feel your eye roll when it should be simpler and it's not. Unfortunately, that's job security for me, usually. Not that I like those phone calls, but I get them all the time. Okay. Other questions? Yes, sir.
Back to classical cards.
Mm-hmm. Good for you.
Daughters, my daughter really don't care about it. But as soon as he became like 7 years old, I told him these cards are yours. I go, should I sell them to him right now?
So the question is, and I want to repeat this, and again, I'm going to summarize. So let's say that you have a very special particular asset. The example here is classic cars. So something that has real world value. And in this scenario, a beneficiary who's very involved and maybe potentially other beneficiaries that are not. Is that a fair statement? Okay, fair statement. Yeah, if we've got classic cars and we've got a son who absolutely wants it, I'm not going to jointly own a classic car with any of my kids. I just already know that. I can barely get behind the wheel of my beat up Hyundai Tucson with my 17-year-old who's very responsible. I can't imagine what it's going to be like for my 4-year-old fire starter. That's going to be a difficult time. If I owned a classic car, I would never share it. I would never jointly own it. I also wouldn't sell it to them. I would go back to my planning documents and just say, if I still own it at the time that I die, then I do want it to be transferred to them. And in that case, I want to be fair to my other kids. Just because they're not interested in my classic cars or my gun collection or my, I don't know, my baseball card collection, it still has value. But if I want the specific person to get it, I want it to get them after I'm gone, after I'm done enjoying it. But I'm selfish. I like my stuff and I want it. Nothing would prevent you, though, if you put that in your planning. Hey, if I still own it at the time that I die, I want it to go to this particular child. Nothing would prevent you from gifting it ahead of time or transferring it to them or selling it to them for $1 ahead of time, whatever you do think is appropriate. It's up to you to decide what's appropriate because you do have other children, 2 daughters, that you want to be fair to. Fair doesn't mean equal, right? It's very hard to get to the penny and everybody gets the same thing, but it might be fair for a son to get the classic cars and for daughters to just get the cash equivalent to account for that and then divide everything else equally.
The problem is plastic cars are worth real money.
Absolutely.
All of a sudden, the girls wake up and they say, hey, we want part of those.
They're your cars. This is tempering the expectations of beneficiaries. If you have things that you know are a real world value and you choose to give them and not equalize, not provide the same thing, it's mine to do with as I see fit. I'm a difficult father, but I grew up with one and I love my father very dearly. But there was an expectation. I was raised on a farm. You worked. I say this facetiously. After becoming a lawyer, now I can say I worked for a living before I became a lawyer because you earned it. And that would include things like my dad's got a old, Chrysler New Yorker push button transmission that's sitting in a barn somewhere. And he's always wanted to restore it, but he's never had the time or the money to do it. And I would love that, but I don't have the time or the money either. I've got a couple of other things I've asked my dad about, but ultimately I know dad's going to decide what's appropriate for everybody. And if he ends up giving me a chicken and a tractor, well, then I'm getting a chicken and a tractor because that's what dad thought was appropriate. It's your stuff. Do what you think is appropriate. I, as a parent, as a father, don't come complain to me about what you think you're supposed to get. 18 and alive. After that, it's all bonus at that point. And I know that that is a harsh stance to take in these times, but it's also, I need them to understand that it's my stuff and I'll do with it as I please, including, well, I might decide to wrap it around a light pole. It's my classic car. I'll do whatever I feel like with it. They might take my license and have some other complaints. But if I do that, I do that. I would just be very clear. I know that's a difficult conversation. It's easy to say when it's not my children. It's still a conversation I have no problem having. My father has never had a problem having uncomfortable conversations that I didn't want to have when I come to visit with him. We need to talk. I was just here for Thanksgiving. Can we just have dinner? Nope, we're going to talk about something. Okay, I guess we're going to talk about something. But being very clear. And again, sometimes it is that conversation of coming with preloaded answers to their questions. Well, where's mine? I've provided for you in a different way. Don't worry about that. And I've decided you'll get something else. Maybe you guys get you're 50-50 on my retirement account because he gets all the cars that are worth a lot more money. And by the way, you need it because you guys didn't save any money for your retirement like I told you to. You didn't listen to the Carlas and the Nathans and the Kevins and the Daves of the world. So I would tell you, do what you think's appropriate. Selling it now, giving it away now, I think that's probably something that's the cart before the Camaro. You don't need that right now. It would be hey, I'll give it to you later. Or maybe I'll gift it to you or we'll work out a transaction when I'm done driving. When I've got my license taken away by the doctor, maybe we'll talk about it then. But it's too early for that conversation at this point. You're a young man, sir. Don't think for a second you gotta deal with anybody about your cars at this point.
Nathan, there's a couple questions in the chat.
Okay.
One is,
yeah.
What are the pitfalls of online trusts and wills?
I'm going to answer that one. What are the pitfalls of those online planning documents? Well, Rocket Lawyer doesn't send a lawyer to go defend the lawsuit or to deal with the dispute or to come and interpret the will. They don't do that for free. And the number of people who prepare their own distribution planning document, whatever that is, that ultimately they fill it out wrong, they don't actually execute it correctly, and so therefore it's ineffective, or they just didn't understand it, is numerous. The number of times I get people who say, well, I bought this thing from Susie Orman. That's fine. Susie Orman is a wonderful speaker, and she's a pretty good advisor, but she should not practice law. Because I don't practice financial advising. I don't practice banking. I don't practice insurance. I barely practice dodgeball with my kids on the weekends, and they beat me. Don't. Online planning, online tools, the sort of mass trust systems. First, my personal experiences. Well, I think that's the unauthorized practice of law. Those are some pretty gray and loose rules. Nobody's really enforcing it. But second, even if you buy it, often people don't know how to use the tools because now you're asking unsophisticated people to complete a very sophisticated document. That's impossible. That's more than, threading, camel through the eye of a needle. And so it's rife with mistakes. I would love to say I'm a perfect planning lawyer. No, I've clearly gotten things wrong. Thankfully, most of the time it was on the draft. I misspelled somebody's name. I wrote in the wrong successor or the wrong order. Great, we can fix it before we finalize and sign it, where we go through and we confirm this is exactly what you want. Those online programs, those online documents, they provide little to no feedback, and they don't defend, they don't guarantee, there's nobody to go after because it's going to be, if there's a mistake, they're going to say it's your mistake, not my mistake. So that's the first one. Carla, you said there was another question.
Yep, Nathan, so what are the tax issues by putting a rental property on a transfer on death versus a trust or LLC?
So one of the major, the question is about putting rental properties, a beneficiary designating those versus having them pass through a will or through a trust. And the number one is it's a capital gains tax issue. Anybody here own rental properties? Okay, you're brave people. I don't because I don't like dealing with tenants. They're terrorists and I don't negotiate. Ultimately, rental properties, if they pass by beneficiary designation, that's considered a gift according to the IRS tax code. And therefore, whatever your basis is in that rental property, the basis transfers to the beneficiaries at that point. They don't get a step up like assets that pass through a probate or through a trust administration under the tax code. So if you bought a rental property years ago for $100,000, and at the time you die, that rental property is increased in value to $300,000. Well, the beneficiaries still have your $100,000 basis. And let's say that they're not willing to deal with the tenant terrorists. They're not willing to unclog toilets at 2 o'clock in the morning or to accommodate the emotional support animal or whatever it happens to be. And they just want out. Well, potentially they're going to pay capital gains tax because it was beneficiary designated to them on the $200,000 of gain. And so that's usually the downside risk of using beneficiary designations for real estate. Same thing goes for the house. That's one thing I kind of like. Most people's primary residence is the same situation. Even though it's not investment property, you're not anticipating making money off of it. Most beneficiaries don't keep the house. Very few do. Every once in a while I see it, it makes sense, but most don't. And the same thing applies. If they turn around, they're the beneficiary, and they turn around and sell it, they're going to get your basis in it, whatever that happens to be, and they're going to pay, and they're going to give away, rough estimate, 15 to 18% to the government in cap gains tax. And I think that's a conservative estimate. So I'd tell them I prefer them not to do that. Was there another question, Carla?
Yes. What is the average cost of an attorney versus online trust and wills?
It's what's the average cost of an attorney? I wish I had a good answer because I know. So if you do your online planning, they're just going to quote you very much an a la carte. What do you want to buy today? You want to buy a revocable trust? Well, that's a widget, and we sell widgets for whatever the price is. And I don't go and price them. I don't keep track of them. I'm sure that the cost is less than talking to an advisor, but there you're just paying for the widget. You're not paying for the experience and the advice. And that's a great way to make a huge mistake that'll cost you a lot more in experience and advice later. Typical. I can give ranges in my office. It's very expensive to hire a lawyer directly. But estate planning it's a two-way street between a client and a lawyer. If the way we do it, you have to do homework before you come to my office, because the last thing I want to do is for people to come to my office unprepared. And we spend the first hour sitting down gathering basic information when I can ask you to do that before you come to my office. So you get an estate planning questionnaire. And I would think most good estate planning lawyers, here, you're going to get an estate planning questionnaire. Do the homework before you come see me so we can have a productive conversation. The homework should be the client, not the lawyer or their staff. So you don't have to spend that money. Most lawyers bill hundreds of dollars an hour. Most paralegal staff are hundreds of dollars an hour. Even if it's less, it's still a lot. And ultimately, what I want to do is get to the conversations that we're having here. What's the right distribution planning document? Let's talk about that. Who should be in charge if it's not you? Who are our backup decision makers? What should that distribution planning look like? Are there special provisions? Are there unique considerations? That's what I want to spend my time on, not can you get the correct spelling for all of your kids? Can you make sure I got that right before? Can you get their contact information? This is just not complicated. When it comes to cost, that's how we keep our costs down. I would tell you I can give you estimates, but every lawyer has a different process. We bill by the hour, and I know plenty of lawyers who bill on a set fee basis. We bill by the hour, but we give estimates typically for estate planning. If you're a single person and you're going to do basic will planning in our office, which often involves a healthcare power of attorney and a financial power of attorney as well, you're going to spend probably $800 to $1,000 for basic will planning. If you're a couple and you're going to do the same thing, but these are mostly reciprocal documents, each to the other, everything to the same beneficiaries, it's not quite double, but it's some more than that. And if you're going to do revocable trust planning and you're a single person, it's probably going to be in that $1,500 to $2,000 range. For couples, it's not double that. Maybe it's at $2,000 to $3,000. But I know plenty of other lawyers who, big downtown Milwaukee law firms. They don't talk to you unless you're going to spend $10,000 because they bill at $800 an hour. And they're going to have 3 lawyers sitting in every meeting with you. So it's not just $800 an hour for one lawyer. It's $800 an hour for the senior partner, $600 an hour for the junior partner, and $350 an hour for the associate or the paralegal, the estate planning, senior paralegal who's going to be on there. So these are $1,500 an hour conferences. Well, but these are people who have that kind of money to spend. So that means nothing to them. I don't know these people. They never walk into my office at 88th and National. I represent regular people who did work hard for their money, like I remember doing many years ago, and don't tend to part with it. So you be reasonable with them. And so that's why I give those ranges. They are ranges. Every once in a while, they come in, clients, and the planning changes, or we've had a different idea, or something drastic happens, and we have to change course and do something drastically different than what we talked about. But that's less than 5%. 95% of the time, clients do the work. We have productive meetings. We sit down, we go through, we get them drafts. They tell us what the changes are, if any. We get them in to get it signed. And that process hopefully takes less than 60 days. And those dollar figures I just talked about, that normally works. I know some lawyers who do it faster, they charge more. I know some lawyers who add additional things to it, whether you need it or not. They're going to sell you all the widgets, whether or not you just want to buy one. That costs more money. I know attorneys who just they package it up and it's everybody gets a widget regardless. They don't specialty in anything. So it's your own situation. I would just tell you, you can pay less for the online products, but you're being sold a product, not a service. If you're going to talk to a lawyer, which I highly recommend, it's because you're paying for their advice. You're paying for their service, and that's worth it. If not, I assume I'm going to catch the legal fees on the backside when you make the mistakes.
Real quick, Nathan, 2 things. What if the representative that you chose is in a different state? And then what states are you licensed in?
So I'm licensed in Wisconsin and Illinois, and every once in a while I have someone who's out of state. So if you're in a probate scenario, you have a will and the person you named, either they've moved or they were already out of state, the local court system sets rules that they're comfortable with, which may include some additional things for that person to comply in order to serve as their personal representative. So most of my cases are in Milwaukee County. If you're not a Milwaukee County resident, if you're out of state, they don't have jurisdiction over you. So you're going to have to do 2 things in order for that court system to get comfortable appointing you. One, you're going to have a lawyer serve as your registered agent. meaning someone the court does have jurisdiction over that they can haul into court and yell at if you're doing it wrong from Illinois or Utah or from Florida. The second thing they might do is, even if the will waives the bond requirement, they still might not they might not waive it. They might require you to post a bond, which is an additional expense for the estate when you're normally trying to avoid that. So when you're an out-of-state person, just understand the local rules are going to potentially add more expense or more conditions if you want to serve as an out-of-state personal representative. Other questions, Carla?
I think we're done, Nathan. We appreciate you so very much. We are going to post this on our website in about a week so people can view it at that time. And we thank you very much, Nathan. Thank you.
Thank you, everybody.